Well, thank you, everybody. I'm sure we'll have a few more people join as we get started here, but we will get underway so that we can get to all the great stuff we have to talk about today. So welcome to the Beacon Point virtual discussion. The topic of today's discussion is the 5 estate planning mistakes you're probably making and how to fix them. I'm Kobe Kress, a certified financial planner and wealth advisor here at Beacon Point in Scottsdale. And as a premier financial advisory firm in Arizona and across the country, it's our desire to consistently connect you with high caliber resources that can help you solve the very real financial issues that you face every day. And it's in that spirit that I'm very excited to have with us today, attorney Emily Taylor. But before I introduce Emily, I have a few housekeeping items for you to make sure you get the most out of today's event. So first, up here in the top right-hand corner of your screen, make sure you click through to speaker view. That should give you the best viewing experience for today's event. And then down here at the bottom of your screen, you should see a Q&A button. We have left a good amount of time at the end of the discussion for questions, and don't miss an opportunity to have Emily answer your questions directly. So please use that Q&A button, put anything in there. If we don't get to your questions because of time constraints, we will follow up with you to answer those questions in a follow-up email. So please use that. We want it to be a great discussion for everybody today. So that is house cleaning or keeping, excuse me. Let me do this real fast. There we go. So Emily Taylor of Taylor & Lynn Attorneys here in Phoenix has built her business focusing on long-term care planning, special needs trusts, guardianships, conservatorships, trust administration, probate, estate planning, and much more. She earned her bachelor's degree from Arizona State University and earned her law degree from the James E. Rogers College of Law at the University of Arizona. Emily sits on the board of directors for the Opportunity Tree, which is a nonprofit organization that provides individualized support for adults and children with intellectual or developmental disabilities. And she volunteers with the Maricopa County Bar Association's Probate Lawyers Assistance Project. I can tell you that Emily is a pleasure to work with. She has a wealth of knowledge and experience, and she's been gracious enough to take some time out of her busy schedule to speak with us today. With Emily being an attorney, I think it best to add a disclaimer right at the onset of our conversation. So please know that anything we discuss today should not be taken as legal advice specific to your unique situation. For that, you should seek out an experienced attorney like Emily to help you. So with that, Emily, thanks for being with us today.
Thank you, Kobe, and thank you to the Beacon Point team. I'm excited to talk about estate planning today. It's one of my favorite topics.
Great. Well, we're excited to have you. I think it's going to be a really great discussion. So as I mentioned, we'll get right into it. The topic of today's discussion is the 5 estate planning mistakes you're probably making and how to fix them. So let's start with the first mistake. Well, I think we both can attest that quite often when we review a client's estate plan, we find a lot of gaps. With that in mind, the first mistake for our discussion today is clients not having the proper estate planning pieces that they need. Can you talk about this mistake and what those pieces are that folks should have in place to ensure that both them and their loved ones are cared for in the way that they intend?
Absolutely. A lot of people come to my office and to many attorneys seeking out a will or a trust, specific legal tools they've heard a lot about, and they want to make sure they know what happens to their stuff when they pass away, which is a great goal. We definitely want to participate in that. But one of the things that I see a lot of times is a focus on after death. And so what we want to look at in the estate plan is to make sure our entire life between now and when we do pass away and our estate's been fully administered is covered. And so typically we're trying to avoid contest, trying to avoid court, and we're trying to make it easy for those who we're going to have to ask to help us at that time. And so covering periods of incapacity is really important. So a lot of times we really want to make sure there's a healthcare advance directive. So healthcare power of attorney, living will. The term living will is more specifically, what are your wishes at the end of life? What are your healthcare directives? Financial power of attorney. So what happens if you're alive but incapacitated? Sometimes a trust covers that, but maybe not everything. And also, we do want to make sure that the pieces of the will and the trust are important. In Arizona, one thing that's unique to us is that we have mental health powers of attorney as well. So a lot of people coming from other states may not have seen this before. It's very specific to inpatient psychiatric treatment, something we all hope we don't need. But what we find in Arizona is a lot of geriatric psychiatric. So something that may occur. And our goal in these cases is to have the documents, the decisions in place to help avoid some court processes, primarily guardianship and conservatorship. You mentioned at the outset that I do that work, and I do enjoy that work, mostly because I make a lot of money. Clients don't want to pay an attorney a lot to go through that process. It's very stressful. It's a lot of decisions that are outside of our control. So when we're looking at our estate plan, we're dusting off our binder, we're looking for healthcare directives. We're looking for financial directives that are during our lifetime while we're alive but incapacitated. We're looking for wills and possibly trusts. In addition to that, we've got to make sure we've got all of our beneficiary designations and ownerships and everything else outlined and covered. So that's the big thing. Usually what we're trying to avoid is those situations where I've had a few too many times where somebody went and got their healthcare directive done at the hospital. They went and got a will from LegalZoom, and then they pieced together their estate plan, but they forgot the financial power of attorney. That ends up with us going to court. That ends up with other attorneys getting involved because you have to be represented. And so it's a very expensive, time-consuming, and stressful process during an already stressful time. And so that's one of the big things, pulling out the binder, making sure you've got all the pieces of the puzzle and that they fit together.
Yeah, that's great. So I'm gonna head off a question that I know we're gonna get in the question and answer section. So let's just address it right now.
Yeah.
Somebody's out there, they have a will, maybe they have some of the other things that you've discussed, but they're not sure about a trust. So maybe their perception of a trust is that's only for somebody that's at a certain income level or a certain net worth. I don't need a trust. Can you just give us an overview of why a trust might be the right solution for somebody, and what that situation may be?
Absolutely. So when we're looking at our goals, we need to understand what is most important to us. And so for some people, things like privacy, some people prioritize the ability to control, perhaps after they're gone. Some people really want to avoid court. Some people want to avoid taxes. So looking at all those different goals, what we're going to do, or what hopefully your estate planning attorney is going to help you do, is decide what meets that. And so if we look at what happens to our estate when we pass, when we say the word estate, frankly, I don't care if you have $10 or 10 million or 10 billion. You still have to put somebody in charge and say where you want it to go. So a will does that very nicely. A last will and testament allows you to nominate a personal representative, allows you to nominate a guardian for your minor or incapacitated children, and it allows you to direct where your estate goes and put a few rules in place. A trust does a lot of those same things. It's still a rule book or a guidebook. Allows you to decide who's going to be in charge, allows you to decide what rules are in place, and it allows you to decide where everything ends up. But one of the things that is primarily different between the two is that a trust only controls those assets that are in the trust. And so when people say in the trust, and this is kind of a mistake that happens sometimes, people will say, well, it says right here in my trust that my car is in the trust. Well, just because you type it in there doesn't mean it is. But ownership wise, the trust directs when that trustee can step in. And in last will and testament, you nominate a personal representative, but that personal representative doesn't have any authority until they've been appointed by the court. And so that court appointment process is called probate. So probate can be avoided by having a trust. So having that trust in place and fully funded allows you to put that person in charge without having court supervision and court control. It also avoids the public nature of a probate proceeding. And then with trusts, a lot of times what we can do is also add in some different measures that allow for tax savings. It allows us to build a bit more structure in terms of longevity of control. And control sometimes has a negative connotation. That's not always what we mean, but sometimes we need to be able to continue that on for a period of time. So do I need a trust? Well, if your goals are to avoid probate, and your goals are not as simple as everything goes to one person by beneficiary designation, then a trust is a really good tool to help you avoid the court process, put a few more strings on your estate, and to really build some depth there. So no, not everybody needs a trust. Do some people want a trust? Absolutely. But you need to have a conversation about what your goals are. Does that help?
That did. Yeah, that's great. I think you really nailed it on the head when you said that it's a tool, right? It's a tool in the tool belt. And that's why the estate planning process is so important, because we want to go through that process and make sure we're using the right tools. A trust may not be the right tool for you, but it very well may, and it may be the right tool for you in a way that you didn't anticipate ahead of time. So I think it's very important to view them that way.
Absolutely. And the other caveat to this is there's many different types of trusts. A lot of times today we'll be talking about revocable living estate planning tool trusts, but there's a million different types of trusts as well. And so really having an understanding of what your goals are can help a professional kind of craft that for you and make sure you get what you need and what you want.
That's great, Emily. So I think this gives us a great framework to look at the other 4 mistakes that we're going to discuss today. So let's talk about mistake number 2. Quite often I speak with folks, and you kind of hit on this, they have a will, they have a trust, maybe they even have the proper power of attorneys and the other pieces that we've discussed, but it was all written back in 1997 and they haven't revisited it since. So mistake number 2 for you to discuss is clients not updating their estate plan.
Absolutely. So I do get a lot of people who come in and say, well, we did this when we had kids, right? The children were 3 and 4, and now they're 30 and 40. So there is a lot of time that can go on, and our plan is we absolutely want to have an estate plan for right now, the what if, the bad things that could happen. But it is dynamic and things do change. And so reviewing and updating your estate plan is really critical. One of the biggest things is obviously family dynamics change. So who you've named in these different capacities. A lot of times when you have young children and you're putting or nominating guardians in your documents, you look at grandparents. Well, 20 or 30 years later, grandparents may no longer be appropriate to have roles in ongoing longevity. So we want to look at who's appropriate players that can change. Divorces happen, marriages happen, name changes happen, all those different things. And so a lot of the family dynamic can impact what your estate plan says. And a lot of people are surprised. They do their estate plan, they check it off their list. They're able to answer their advisor's question, do you have an estate plan? And they say yes. So they feel really good about it. And then they pull it off the shelf and they realize, oh, I can't believe I put this neighbor in there. I haven't talked to them for 15 years. So family dynamics is a big one. This day and age, we were kind of talking about technology and how that's all very rapidly changing. Technology plays a pretty big role in the way we live our lives, our financial lives, our healthcare lives, and it's only going to continue to increase. So one of the things we want to look at when we're looking at our estate planning documents is, do they address those changes in technology? Do you have your agent having authority to manage your digital assets? Can they go in and shut down your Facebook or your Google account? Can they get access to your airline miles? We live in a digital world, and so your documents need to address that. The other thing is laws change. So laws, especially as it relates to taxes, change on a regular basis. And I know we're going to talk about that a little bit more. But that can play a really big role in the initial creation of your estate. So in 1997, we were doing much different tax planning than we are right now. And so a lot of times those estate plans, I can almost guess what it's going to say. And in many cases that no longer applies or is no longer necessary. So making sure that all of the documents address current rules and current laws. And then, you know, I think the biggest thing that really we keep coming back to is the dynamics of picking good people. Or professionals to make these decisions for you, putting a lot of power in other people's hands. So really looking at the people you've named to make these decisions and kind of reevaluating whether or not they're still the right people to have in place.
That's great information. You hit on something, and I'm springing this on you, so if you don't have an answer, that's okay. But when you said new technology, that made me think of some things I've heard about. I haven't experienced this firsthand, but folks who have passed away and they had maybe a big digital library or things like that, and they had honestly thousands of dollars invested in their music on iTunes. Have you come across that, and how does a trust help us to address that?
Sure. So you own a lot of content and most of it's personal property, right? You can look around my home and you can see my plants, for example. That's mine, I own them. And if someday somebody needs to sell them or give them away or have authority to take action on them, I assign my personal property to my trust, and I give my power of attorney the authority to do things like that. Well, our online and our digital content has the same ownership rights in large part. And so we still need to give someone the authority, and we need to make sure that that authority is clear. So a lot of times people will mention digital currency, which is a very unique and changing area all the time as well. A lot of people have concerns about artist rights, so a lot of graphic designers, people who own content, people who have rights to that. It's about giving somebody the ability to control that asset in the same way you have that ability, and being clear about it. And so when I started practicing 13 years ago, our little digital asset section was 2 sentences, and now it's probably the longest paragraphs in our document, because frankly it changes all the time, and it can be a headache for people who don't have that authority. So yeah, it definitely needs to be addressed.
That makes a lot of sense. I'm going to add one last thing to that. So we've
Sure.
talked about having in the trust, and when you said something about them having the proper authority, it made me think of durable power of attorney, power of attorneys, having the proper ones in place. So I imagine that's tied into that as well, right? Making sure the proper people have access.
Yeah, so there's a little bit of overlap between trust documents and financial powers of attorney. Financial powers of attorney are, again, alive but incapacitated. So somebody's had a stroke, somebody has dementia. For some reason, they can't make their own decisions about their finances. Trust documents are going to control the assets that are in the trust. One of the common tools or things that people will do is they will assign their personal property to a trust. That being said, sometimes some of that digital content is a business, or is involved in a business, or for some reason isn't in the trust. But both of those documents should allow for somebody to make those decisions. Often it's the same person or team of people. They're just wearing different hats. Are we calling them the power of attorney, or are we calling them the trustee? Same for bank accounts. It's a good way to kind of show it, is that you might have a checking account that you left outside of your trust, and at this very same bank you might have a savings account. And you might be frustrated with me when I tell you to bring both documents, because for that checking account outside the trust, you're going to need the financial power of attorney. For that savings account, you're going to need the trust. So it's similar roles, similar period of time, but just different legal authority. And so with the digital piece, we don't know where those assets are going to be, what documents they're going to want. So that's why the plan needs to cover both. Does that help?
That does. That's great. So now that we've hopefully convinced folks to take a look at the dusty old trust document that they had tucked away in their filing cabinet for the last 15 years, let's talk about the third mistake that we see so often, which is the improper ownership of assets and not accounting for the different tax situations of your beneficiaries. Can you talk about that a little bit for us?
Sure. Two similar, but again, overlapping areas that often arise, and sometimes will result in somebody having a very well structured and designed trust document, but still not allowing the accomplishment of our goals. So if we look at all of our assets, and this is part of what you as advisors help people do all the time, we have different types of accounts owned by different people, by different structures. And so what we're always looking at is the asset going to pass by non-probate transfer at your death? And the answer can be yes, it's in a trust, which is great. That's going to follow the rules of the trust. It may have another non-probate designation. That could be co-ownership. So a lot of folks in Arizona own their houses as community property with rights of survivorship. So the first spouse passes, it typically passes to the other spouse without a need for probate. That is also going to avoid probate, and that may be part of our goals. Sometimes that is matching with our intentions, and sometimes it's not. And the other thing we really rely on is beneficiary designations. And so beneficiary designations on accounts are going to control. So any beneficiary designation or legal ownership, you could have the fanciest trust you've ever seen, and it's not going to matter if nothing is flowing through it. So the big gap there is making sure we understand what we have, making sure we understand who owns it, making sure we understand, is there a co-owner or a beneficiary, or should it be in the trust? and making sure it gets there. So that trust funding is really important. Sometimes it's okay that we have beneficiary designation. Sometimes it's okay we have co-ownership. That might be part of our plan. But it's just really important to distinguish, just like we talked about, which hat is that person wearing? Which way do we want things to go? And so the second piece of that, well, I guess the big concern there is probate, because like I said, you can have a big fancy trust, but if you had a house that was just in your name and you passed and it didn't have a beneficiary on it, we've got to go get probate to put that into the trust. So the other big risk, like you mentioned, is taxes. So a lot of what folks have are retirement accounts, IRAs, 401ks, all sorts of different plans. And as we know, those types of accounts remain in our individual names. And so they're not going to be retitled in the name of the trust, and we're usually going to rely on beneficiary designations. Now, I mentioned earlier that tax laws change, and that's one thing I think we can guarantee. They're going to continue to change. If I read the news correctly this morning, they just did another act that they put in some more kind of changes to what we had. So in December, we had the Secure Act. Earlier this spring, we had the CARES Act, and then I am spacing on the name of the new act they just passed. But all of those have changed how we look at our qualified retirement accounts, what rules we have in place. But that plays a role in what we're looking at as part of our estate plan. So having specific detailed conversations with our financial advisors, with our estate planning attorneys, we can then go back and look, hey, 20 years ago, we had this retirement account going to our spouse and then to our kids individually, because we understood that as being a positive tax plan. Is that still true? One of the things that's been changed is with the Secure Act, the ability to stretch those retirement distributions has been limited in some cases. I do a lot of special needs planning, and so historically we would try to avoid that for certain reasons. Now, that's one of the few exceptions to the Secure Act. So you've really got to know somebody or talk to somebody who can direct you based on your information. You asked about tax consequences to individual beneficiaries. Money coming out of retirement accounts is income. So if we look at our family, sometimes we have really high earner children. We're going to be in a totally different tax bracket than somebody else. Sometimes we can manipulate that to make it more advantageous to minimize or reduce taxes. So it's a bit of a puzzle. It's a changing puzzle. And it's another reason to look at what you have, not only in that dusty binder, but also the designations you've had for your long held accounts. Maybe dusty as well. So
I'm glad you hit on that, because that was what was coming to mind while you were talking about this, was not being able to stretch IRAs, right? So we used to be able to stretch that out a much longer time period over the life of a beneficiary, depending on circumstances. And now we're restricted that a beneficiary has to have that account drained within 10 years. So where
certain
that
beneficiaries.
Say that again?
I said certain beneficiaries.
Certain beneficiaries, yes.
Yeah.
Yes.
So when children used to be able to stretch based on their life expectancy, they've narrowed that to the 10 years. But there is an exception for special needs children or qualified disabilities. So they changed it in a lot of ways that are going to affect a lot of people, but it's not necessarily intuitive. But yes, you're right. That's a big change.
And I think it paints a picture of why going through an estate planning process, not just checking the box and thinking, I have my trust document and a will and I'm good to go from here, but an ongoing process, very much like the financial planning process. We need to keep addressing these things because things change and they can have really big consequences. If you have a child who's set to inherit your IRA, or maybe you're splitting it among children and one of them's a very high earner, well, they may pay a lot of taxes in that. And we may be able to go a different direction and leave them taxable assets or a Roth IRA so that they're not facing as high of tax consequences and more of your wealth that you're passing down is not being sent to the IRS. So there is planning to do around that. And I think it's important.
Absolutely. And I think it's really important that you make sure your estate planning attorney is communicating with your financial planning team because they work together. And they can't do a great job working individually. So that's why it's fun to be able to have conversations about it and make sure everybody's a part of the same plan.
Certainly. Yeah. I think when things get disconnected, that's when you end up with some issues. I've heard some horror stories from estate planning attorneys I've worked with where there was not good communication and there were estates that went a little wonky. So I think you're absolutely right. Having a team around you and making sure that team communicates is important. So I'm going to transition us here for our fourth mistake. I want to shift gears just slightly and discuss something that's a bit more narrowed in scope and happens to be the area of focus for you in your practice, namely not establishing or the improper establishment of guardians for minor children and those with disabilities. Can you talk about this often overlooked step and what people should be doing to make sure that the ones that they loved are cared for?
Yeah, so a lot of this has to do with what stage of life you're in. And so a lot of young families who have young children, we hope that they're going to be the parents until these children are 18. And when they're 18, they're adults, whether they act like it or not. And then, of course, there are certain people or individuals who may need ongoing decision-making assistance, and that's through the guardianship process. So the term guardianship we kind of talked about before as it relates to ourselves. So if I've never signed a power of attorney and suddenly I get hit on the head, somebody's going to have to go to court to take away my right to make decisions and give it to somebody else. That's an adult guardianship. And that adult guardianship process happens to any one of us on this call today, but it also happens to somebody who's developmentally disabled, who's turning 18. We have to go through an adult guardianship process. There's also a minor guardianship process. So when a young child, somebody under the age of 18, no longer has a parent to make those decisions for them, there's a process in which the court appoints somebody else to make those legal decisions. Sometimes that's part of a family dispute or things like that. But if tragically parents are deceased, one of the other processes that comes up is that we need to be able to get somebody in place in relatively short order, because we're presuming there's been a crisis, something needs to happen. People are going to need to make decisions. Sometimes that means travel decisions, that means education decisions. And so in your last will and testament, this is the document you're going to instruct this in. Even if you have a trust, you're going to make the election to give somebody priority. And so what you're doing is deciding, who do you believe would be the best person to be appointed by the court to make those decisions for your children? And sometimes that can be hard because we've got two married people, each with their own families, each with their own parenting styles. Hopefully they've come together, and but figuring out, who do we want who's going to raise our children or make decisions in the way we would. That's not always the same. And the other thing is that you have to remember that guardian doesn't always equal custodian. So a guardian could choose it may be better. So a lot of people are struggling with, well, my family's all back on the East Coast. I really think my parents, they did a great job raising me, so they do a great job raising my kids. But I also think it'd be important for my kids to stay here in Arizona. That can happen. So it's about decision making. And so putting that decision in writing can help. The other thing we overlook sometimes is there's a lot of families that have a lot of disagreement. And when there's grief and stress, some people who have been pleasant your whole life may not be perfect. And so by giving the court some direction if people are fighting can really be important to minimize conflict in these children's lives. So nominating that, and then guardianship for an adult, again, if you have an incapacitated child and you've been appointed the guardian. And then typically what we see is, as you age, we often appoint a sibling or somebody of that individual's generation as a co-guardian. But if we don't have an opportunity to do that, you can nominate who you wish to prioritize for that appointment.
Where would these nominations take place? Clarify that for us. Do these take place within a trust, within the will? Is it a separate document? What do they need to do to make sure folks are taken care of?
Typically in our Arizona statute, what we are allowed to do is nominate in our last will and testament. Our court system has a process. So for example, when we're talking about the probate court, that encompasses probate. It also encompasses supervision of trust administration and guardianship and conservatorship. We have a probate registrar, a shortened way to be able to get things done. We can do an informal probate that way. We can also do the guardianship procedure that way. So if we have an original last will and testament that gives nomination, we're not going to have to go through the 45 or 60-day waiting period. So having it in that last will and testament is really important. The other thing, parents may want to do is put together an emergency plan. So just a written document that isn't necessarily legal in nature, but it's in case of emergency. Here's where you're immediately going to go. Here's who has authority to transport you. Here's a parental power of attorney in case they're incapacitated. Some things like that. There's a lot of nuanced just options there. And in the special needs planning arena, we tend to call those letters of intent. You know, these parents have raised this young adult for their entire lives, and they know things about the medications and the medical history and the benefits planning and all of that. And so we a lot of times take for granted how much we have hanging out up here that really would be really helpful for whoever might have to take that into place. So that kind of concept of how do we plan for these people who can't make their own decisions is largely based in putting things down in writing and having something that's enforceable and quickly, because things need to be made, decisions need to be made quickly.
Yeah, anybody that's been through that experience knows that things move quickly, they need to move quickly, and trying to scramble around and find the right information and where it is, that can be a really difficult process. And I think this actually leads very well into our last question. But before I get to the last question, I want to ask everybody out there, just remind you, the question and answer button at the bottom. We have some questions coming in, but love to have some more out there from you. So if you have questions, don't miss this opportunity to have Emily address them. And like I said, if we don't get to them, we'll send a follow-up email with an answer as well. So please make sure you're using that question and answer at the bottom. We do have some good questions lined up already, which is great, but we'd love some more. We want to make sure that we're answering questions that are important to you. So with that, we've come to our final estate planning mistake. And I think it's an extremely important, but also at times a bit awkward. And that's the mistake of failing to communicate estate planning details with those who will be affected by those details. One area where I see this a lot, I'm sure you see it as well, it's maybe with parents that are reluctant to talk about their estate plans because honestly, it's awkward and it's a little bit depressing and maybe uncomfortable. So can you talk a little bit about this mistake and how you encourage folks to discuss their plans or the plans of their loved ones? And I think this does tie into what we just discussed, because part of that is just a discussion around where are the items that we need? Where is the will? Who do we contact? So all of that I think is important.
Yeah. This to me is one of the biggest pieces that can be most helpful. I see a lot of conflict come into my office when somebody's passed or when somebody's incapacitated amongst family members who survive. And there, of course, are families where this communication isn't going to be appropriate or isn't going to be available. Those are typically outliers. And so what we see is a lot of kind of generational comfort with communicating. So I like to use my family as an example because I can, it's not confidential. But my grandmother wouldn't even go see an estate planning attorney. If you talked about it, it happened and it was bad. They had lost a child at a young age and so they wouldn't address it at all. When she passed, everything was jointly owned. It caused some kind of tax planning things that had to be happen, but nothing too big. My grandfather, on the other hand, he was a farmer. He understood the value of having an estate plan, having an attorney, and then sharing it. And so in our family, we have farm meetings every year. There is no longer a farm. My grandfather has passed, but it's that every year we sit down and my parents say, this is where all of our documents are. Here's our password list. Here's our expectations. Here's what we've updated. That's pretty progressive in the sense that not everybody's comfortable doing that. In our case, it works because the 3 children are grown and financially independent. So there is no sense of need. But on the other hand, what it's allowed for is for us as children to be able to plan for what happens. And so as our parents are starting to age, we get to see, well, you know, Emily, you're going to be handling the trust, and Adam, you're going to be handling the financial or the healthcare powers of attorney. And so having those conversations and being able to communicate, well, what is it that you want, Mom? Because advanced directives, for example, they have some legal language in them trying to tell us what we want at the end of our lives. We can't begin to imagine the decisions we're going to have to make about nursing homes and feedings and medications. And so having some conversations can be really, really helpful. What I typically recommend is that if you don't feel comfortable sitting down and looking through the documents and going over them with your children, with the people you've asked to participate, is to at least have a conversation that says, we've taken this step. We've done these documents. This is where they are. Here's who we've worked with. We prefer not to share the details right now, but in case of emergency, we've authorized our attorney to share with you these documents. In case of emergency, don't run off and get that guardianship and conservatorship, that court process that's expensive and stressful, only to turn around and find out that we've done all of this, because that happens. We've been retained for guardianships and conservatorships, done thousands of dollars of legal work, only to later have a garage sale and find that dusty old binder. So if you're not willing, because I can understand it can be uncomfortable. The other inverse of that is very, very true, is that many times we're looking at our parents, and perhaps our parents haven't shared with us. And so it can be hard to broker the subject, and, not to say, hey, mom and dad, when do I get my inheritance? But more realistically, we're kind of at the perfect time to start this conversation. You don't turn on the news, you don't read a newspaper without hearing families having to make some difficult decisions through FaceTime and that kind of thing. It's not fun to talk about, but it's a lot less fun to talk about in the immediate circumstance. And so by starting to ask those questions, sometimes you open a can of worms, you're going to hear all sorts of things. And it can be really good. And sometimes people will clam up, but at the end of the day, you can say, well, have you addressed it? If you haven't, I recommend you do, and leave it. So I would never recommend you stress a relationship because of it. But on the other hand, if it just hasn't been talked about because that initial question hasn't been asked, sometimes if you ask the initial question, you can have a really productive, good conversation.
And I think maybe even just a list of contacts, like you outlined, right? If you don't want to have the conversation, you don't want to get into the details, just a list of contacts is very helpful, I think. It should include your financial advisor, your estate planning attorney, who those guardians are going to be, folks like that. So people at least have a starting spot. That might be a way to ease into the pool.
Yeah, one of the things, we used to rely on the mail. If we need to find something out about mom and dad, go steal the mail, because they were getting bank statements, they were getting tax forms. We get all that through our email and digitally now, and so it's much harder. In our office, when we're doing estate plans, we typically hand out a book. There's two versions of it. It's exactly the same, but it's an old-fashioned, it's not really old-fashioned, but it's handwritten, right? It's not that Excel spreadsheet. It's not that tricky new app. It is just a book that allows you to answer some very basic questions about who's your team, who should be contacted. One version, and they're available on Amazon, is called I'm Dead Now What? So it's a little crass. The other one is called Peace of Mind Planner. They have the exact same inside contents. Happy to give them away. But they're a good tool that just can be a part of your estate plan that doesn't have account numbers or passwords or things like that, but it just says, call Kobe, call Emily. This is who you need to talk to if something happens.
That's great. So I think this has been great. I think we've covered a good amount for folks. Hopefully they can see maybe some gaps in their own estate plan, some areas that need to be addressed. Hopefully it opens their eyes to some of the things out there that are important to have in place. We know these conversations are awkward. Emily and I have them on a regular basis. So hopefully this will help you just start that conversation with the people that are important, because part of having an estate plan is leaving people prepared for when you're gone. You don't want to leave them with a mess or with extra stress. They're already going to be obviously devastated. We want to make sure that that process is clean and neat, and they have the support where they need it. So I think all of that's been really great. We have about 15 minutes or so left to address some questions out there. And I want to remind everybody, we've had some great questions come in. I think we're going to have a good amount here. I just had another one come in as well. But please use that. If we don't get to all of your questions, we will follow up with an email with an answer to those questions as well. So I'm going to dive right in, and actually we're going to take the one that just came in first, because it applies to what we just mentioned here. There's a request that you repeat the name of those two books.
I'm Dead Now What? It's literally got an image of feet with a toe tag on it. So it gets a lot of laughs, but it also gets a little cringe sometimes. It's just a graphic image. The other one's Peace of Mind Planner. I think they're $8 on Amazon. They're hardcover, but spiral bound.
Perfect.
Yep.
So first question I have here, we have a lot of technical questions, which is good, kind of little pieces that people want to know. How often do you recommend folks have their estate plan reviewed?
I recommend that every year their financial advisor should be probably prompting some questions, or at least being able to see some red flags being raised. But in terms of coming to see an attorney, of course, if life changes, that's obviously a time you want to do that. But otherwise, I'm looking at every 3 to 5 years is a good schedule. If something changes in the law, usually you'll hear about it. That being said, it's May and people are still learning about the Secure Act, so it's not always obvious. But most of the time, every 3 to 5 years, having a quick call. It doesn't need to be a full sit down, dig through everything, but having a good look at what you actually did and having a conversation with your attorney is a good idea.
So this is actually great. This leads into another question that we have right here, and it's, so I've changed attorneys and an update needs to be made. Mm-hmm. Will they recreate all the documents, or will they be able to just change what I already have?
It depends. So usually powers of attorney, we're doing all new documents. Those are generally forms. I mean, people come in and say, well, it's just a form, and it is, but hopefully it's not always. Hopefully we've put some time and energy into making it represent what your wishes are. But powers of attorney as a document tend to be one document. So for updating people who are going to make those decisions, it's a whole new document. It's not a bad idea anyways to get the latest tech stuff. But those are pretty easy. Wills, you can do a codicil to a will, which is an update. And with trust, you can do amendments. So the question is, which do you need? And a lot of times, people hate the answer, it depends, but as an attorney, I have to give it a lot. It depends. First of all, if I have a client coming back to me and they want me to make an amendment to their trust, one of the first things is, did I draft the trust? So do I know and understand every component of it, and so I can feel comfortable that changes I'm making aren't disrupting another part of the plan. 2, how many amendments have been made? So after a while, we've got our first, second, third amendment. It tends to become a puzzle, which is taking away from our goal of making things easier. So with a trust, typically what we're doing is, if we're making amendments, eventually we're going to do a restatement. We're going to put the puzzle back together and we're going to do a whole new document, a whole new instruction manual. So it all fits in one place. That doesn't mean we're going to change the trust name, because we don't want to have to do all that trust funding again. But that document itself is going to be a restated trust. Now, if this trust is something from another state that's got some crazy old tax laws in it, and we're changing players, and even if you've never had an amendment, in some cases, I'm going to recommend a restatement anyways. So that's the it depends answer. I think finding somebody who will communicate with you why they're doing it is important, because you have to understand the value you're getting for the fees you're paying, and I think that's an important part of it. But yes, you can do an amendment or a restatement, and you should be able to get advice about what is better for you.
That's great. So I have 2 here. I'm going to lump them together because I think they're in the same context. One is, how do I put my house in the trust if I have a trust? And I would have you expand upon that, why you would maybe look to do that, maybe some of the pitfalls of doing that. And then the other question that goes right along with it, what about my car?
Sure. So homes are deeded typically, with the exception of mobile homes. So a deed is the legal ownership of your property. And so I used it as an example earlier. A lot of married couples in Arizona will own homes as community property with rights of survivorship. So what will happen is when the first spouse passes, it passes into the other's name individually, and that happens without probate, which is nice. But the concern is, well, what happens, first of all, if something happens to both of you at the same time or in short order, or if the second spouse has incapacity and can't then later transfer it into the trust. So typically, one of the common things we're doing, because we want the trust rules to apply to that property, is to transfer the house into the trust. Now, that can be subject to a couple caveats. First of all, if it's not a primary residence and it has some sort of encumbrance, line of credit or mortgage, then we're going to double check and make sure that's not going to cause any problems there. There's another tool in Arizona that we can use as a beneficiary deed, which also avoids probate and would transfer the property without probate into the trust if there's some concern or reason why it needs to stay in there. But typically, we do want to put real property into the trust so that the trust rules matter. When we do that, this is going to be the same for cars, we need to make sure our homeowner's insurance has been notified. They should be notified that your house is now owned by your trust, and you want to make sure you do that promptly. So anytime we do a deed transferring a house into a trust, we're going to remind you of that. But it doesn't hurt for those folks who maybe switched insurance carriers or who knows what else to just remember that. Cars, on the other hand, are a little bit different. So it depends. What we're looking at is title and then probate avoidance. In Arizona, our Department of Transportation has a beneficiary designation form. Typically, if you own your vehicle, I'm not going to recommend going down to title to retitle it into your name or trust, because cars we change a little more frequently than we do at houses. They also don't have the same value, and they also carry liability and a lot of insurance coverage. So typically what I'm going to have clients do is sign some beneficiary designations for their vehicles just to make sure it's easier. But we hope that you don't own the car you currently own when you pass. And so typically we're not going to do that. Now, if we have some very expensive antique car, who knows, then of course that's going to be a different conversation.
That's great info. I do get that question a lot, so I think that's very valuable information. We have a couple more questions here and about 8 to 10 minutes to get through them here, so we're going to pivot here. And this is a great question because these are often forgotten, and I'm glad we covered them already. But a great question here is, what should be included in a good healthcare directive?
Sure. The most important thing, and I can't believe I haven't harped on this about before, is making sure you have the right person named, appointing somebody to make your decisions. So often we presume my spouse, my parent, my adult child. These people are going to be making decisions potentially about continuing your life, ending your life, making medical decisions that may lead to you passing away. They're huge decisions which have a huge emotional impact. And so what you see a lot is that you have in your healthcare power of attorney nominated to somebody to make decisions following your instructions. So you're also going to have some instructions in this document. What do you want? Do you want to be an organ donor? Do you want to have life-sustaining measures? It's hard to make those decisions. Your healthcare agent needs to not only be somebody who's going to follow your wishes, even if it's not necessarily what they want for you, and they need to be an advocate for you. So anybody who's been in the healthcare system recently knows you have to have somebody who can stay on top of all the teams of doctors, all the different types of medications. So it's a tough job. In my particular instance, I would never put my mother on my document. She actually was a hospice social worker. She's very qualified to make these decisions. She'd be a wonderful advocate, but it would break her heart to have to make a tough decision about what I want at the end of my life. So I think in a healthcare directive, you really want to spend some time deciding who you're going to nominate, and you really want to be clear about your wishes. Historically, the living will aspect, the instructions about what you intend, focused on these periods of irreversible comas and persistent vegetative states. This law came out of young women who were in terrible accidents. Realistically, the older we get, the less likely that's how our life is going to pass. And so having some quality of life measures so that your agent is able to take into consideration Alzheimer's, dementia, strokes, heart disease, things that are not necessarily going to result in a coma, but also there may be tough decisions that need to be made. And then most recently, I think our laws are starting to allow for more instruction related to what if you have dementia. So our science has kept our bodies alive a little bit longer than our minds, and who knows when that could change. But if you have specific wishes about what your intentions are, making sure that's in writing. Because again, they're hard decisions to make, and being able to take away some of that stress from the person making it can be really helpful. So they can be powerful documents. They shouldn't just be forms. You should be able to make them whatever you want. But they're tough to think through. So, but good, powerful documents.
I think you made a lot of really good points about really thinking through the people that you assign. And we have a question here, and I think I'm interpreting this correctly, but I think you spoke to it really well. And maybe you can just add on any other thoughts you had, but having that conversation with the folks you plan to assign to whatever role ahead of time. How do you encourage those conversations? What should be included in there? How do you go about that with clients?
So the healthcare one, it's kind of funny. So there's something called the Conversation Project. A woman started it. You can Google it, the Conversation Project. They have a hilarious YouTube video about picking your right agent. And it shows, you know, like the ditzy cousin who's, I'm in Europe, I can't make those decisions, or somebody who's anxious. So the Conversation Project has some great tools. They literally are pamphlets about having this conversation. In terms of end of life, there's a game called Death Deck, which sounds morbid. It's not. You know, Kobe, you and I talked about it. We talk about this all the time in our day-to-day work. I forget, everybody doesn't. But it's a game that's just prompts like a Trivial Pursuit. We played it at Christmas. I said, I have to go get a notebook, because we were having some really deep conversations about, you know, one of the questions is, your spouse dies, what's one thing you keep forever and one thing that you burn immediately? And that burn immediately creates a lot of laughter and lightheartedness to a very serious thing. So people are creating tools to start having these conversations that it's been seen as something that needs to happen. But in terms of starting the conversation, I usually tell folks they can throw me under the bus. They can say, hey, I talked to Emily today. She said I had to talk to you about this. But otherwise, if you could find a kind of a lighthearted, funnier way to do it, that's important. But I definitely recommend the Conversation Project as a way to have a lot of the resources to be able to start the conversation.
That's great. And I think what I'm going to do, because we've had questions around this and you've mentioned quite a few tools that are out there. So in the follow-up email to everybody on the call, I will include links to the books that Emily mentioned, as well as the Death Deck. And what was the other one that you mentioned? Was there another Trivial Pursuit game? Is that Death Deck?
No, there's the there's a number of them. And I also have a handout that I can have you send along as a PDF. That would be helpful. So yeah. A lot of good resources, some a little more morbid than others, but all good conversation topics.
Perfect. Well, I will include all of those in the email that I am going to follow up with. And I think that's about where we are on time. Anybody that we didn't answer your questions, we will follow up with an email as well. So we will get to those questions. But once again, let me close by saying this. At Beacon Point, we understand that these are uncertain and uncomfortable times. And it's during times like these that our clients rely on us more than ever, which is why we're going to continue to provide you with regular, up-to-date, and with what we hope is valuable information. To that point, as I've just mentioned, you're going to receive a follow-up email, and I'd love your feedback and your questions. If you're not currently a client of Beacon Points, but you feel you would benefit from a discussion with one of our advisors, whether regarding your estate plan, your investments, your retirement income plan, or really any other financial topic, please simply let me know by responding to that email, and I'd be more than happy to take some time and speak with you. And as I've said, that email will include not only the resources that Emily has discussed here during this discussion, but also a link to her website. So if you have questions directly for Emily, feel free to follow that link, reach out, and schedule some time to have your questions answered as well. Emily, thank you for taking the time to speak with us today. I thought it was a great event, a lot of really good information to digest, so thank you. We really appreciate it.
Thank you. I've really enjoyed our conversation and really appreciate the opportunity to talk about something I care a lot about.
Absolutely. Well, from all of us at Beacon Point, I want to thank all of you who joined today. Please stay healthy and stay safe, and I look forward to seeing you again soon on a future event.